is stay with the chronology and not kind of get into, something between a summary and the kind of where we're at now. Does that make sense?
I believe it does, Mr. Chairman, and I think what you're saying to me is save it for closing, and, but if my colleague objects on relevancy, I'll move on to something else. Is that a fair analysis?
Sure. I think so.
Okay.
But I mean, if you believe that it's getting too far afield, we'll just renew your objection.
Yeah, continue.
Of course.
All right. We are done with that letter from this one. Now, the next document that the panel has deals with the telephonetic conference, and what is this in reference to? This is dated July 15th.
Well, the court and counsel had a question as to whether father's request to go back to his custodial schedule, whether that request should be granted, whether that was in the best interest of the child. And so we asked Ms. Wyford if she would have a telephone conference with us, because she wasn't quite clear in her recommendations, whether he could go back to his weekend visitation, or if she was recommending visitation only through reunification. And that is what she recommended, that visitation only happen through the reunification therapy.
And in fact, your July 9th order, which is referenced in the chronology, indicates the hearing on Dad's motion for an order to show time in the modified custody, and you're finding that that Wyford's recommendations are adopted, reunification will continue.
Yes.
Okay. And Mom ordered to support the reunification process.
Yes.
Order to show cause and compensatory time for Dad is deferred.
Right, so his motion for order to show cause, his motion to modify custody, it's all deferred, because I'm opting to triage this family through therapy. I think that's the best approach.
Now, on July 15th, there's in fact a status hearing. And I'm trying to be mindful of the chair's directive here, Judge Hughes.
Right.
Okay?
Okay.
On July 15th, there's a status hearing for counsel in the court to call Ms. Wyford regarding those two prior letters that you've already testified to.
Right.
And as a result of that, the Dad's visitation is temporarily suspended in order to occur through reunifications with Wyford.
Right.
So you suspend Dad's visitation rights.
Temporarily, as in
Correct.
the best interest of the child, because it needs to happen through therapy. There is still a valid court order that says he has weekends, and he made that point. He said, I still have weekends, it hasn't been overruled, it hasn't been modified. Judge, why are you making me, go through reunification? I have weekend visitation. And I thought, well, you've had the police over there 7 or 8 times, she's not going. I ordered reunification therapy, it's supposed to happen here, and Wyford recommended that it happen here in the therapist's office. So in the best interest of the child, I temporarily suspended his visits and ordered it to happen in therapy. I thought that was the best approach.
That certainly doesn't show any type of bias against the natural mother. It was a detriment to the father, correct?
Unfortunately, for a very long time.
Okay, now, on August 5, 2015, you received an additional letter from Ms. Wyford. That is at 162.
Okay.
Okay. And generally, this makes you aware that Mom had called the office. She was in the parking lot. The subject minor would not get out of the car. Ultimately, there is no reunification therapy on that day.
That's correct.
Correct? Third time in a row, right?
Yes.
And Ms. Wyford says, if I could be of further assistance, basically let me know. She's done.
I took it as that, and I was not happy with that.
Okay. Now, on 8/25, that was the status of the reunification therapy. And you made a note that subject matter was, again, still continuing to refuse to participate, correct?
8/25, yes.
8/25.
Yes.
Okay.
And I ordered Mom to support it or an order to show cause would issue, and I set a status hearing.
We set a status for 9/29, but on 9/16, Dad files a new motion for an order to show cause and a motion to modify custody based on not seeing the subject minor since April of 2015, and Mom not being concerned with the judge, or as you put it, clueless family court system.
But not my words, those were her words to him.
Okay. And you set a hearing for November 4, 2015.
Well, right, it was initially set right before Thanksgiving, and it was changed, moved up.
Now, there is a supplemental letter by Ms. Whiteford at 165 dated September 2, indicating an inability to pay for her services on behalf of Mom. That fairly summarizes it.
It was a letter addressed to the mother, yes.
Then, at 169, an additional letter of October 8, 2015 from Ms. Whiteford, indicating to you that Your Honor had requested that you do 3 unification sessions, but that basically it did not work.
I'm sorry, which letter are you looking at?
169,
Okay, so the October 8th,
correct?
she conducted the 3 unification sessions with the child and father, thanked them for their participation, and said she would like to continue the therapy.
Right. Did that give you some hope?
A little.
Now, by 9/22, that's when Dad had filed that motion for an order to show cause. This letter comes in October 4th, not that long after that, correct?
Correct.
Okay. We move on to November 20th. Dad's motion to clarify orders and reconsider Whiteford's recommendations. See that in the
Yes,
chronology?
I see that.
And that is set for a hearing, reset for the hearing on 12/8 of 15, correct?
Yes, yes.
Okay. So 12/8, this is the hearing on the motion to clarify, et cetera. And the directive at that point in time, and again, both parties are present,
Right,
correct?
right.
Okay. You give both parties an opportunity to be heard, correct?
Yes,
And ultimately, you direct that Whiteford is to continue the reunification therapy, facilitate visitation for Dad, make recommendations, and Dad is permitted to take subject minor out for an activity,
that's what Wyford recommended.
and the exchange would occur at Ms. Whiteford's office.
She offered her office because Donna's house is not always available. They don't have constant hours. A lot of time parents exchange at the security gate if they can't exchange at Donna's house. She also offered her office if it was like a 7 p.m. on a Monday or whenever they weren't available at Donna's house. She would facilitate, in other words.
And at page 171,
Yes,
an additional report by Ms. Whiteford.
yes.
Okay. Briefly summarize what this report indicates.
I can't. There's no brief about
Change
it.
of the directive of the chair. yeah.
I know, I'm sorry, but it's so many pages, briefly. Okay.
Your Honor, I'd stipulate to allow Mr. Terry to summarize it. Yes,
Okay,
if that's
I
correct.
appreciate it.
Thank you.
Thank you very much. All right. At page 171, she gives a summary of what she refers to as the conjoint sessions, okay? First session, and subject minor did not respond to Dad directly. At a later time, Annie opened up most of the time that they were together. This is page 172. And at the third session, second paragraph, right before the third session, as I'm walking, this is his wife, the subject matter into the room, she was determined to let me know that she did not want to be reunified. Is that accurate?
Yes, after a second successful session, she did a 180.
Right, so finally there had been a meeting between Dad and the subject minor,
Correct.
but that was the second attempt.
Right,
Third attempt, I don't want to be reunified.
right.
Okay. Part of the observation was the subject minor reported that she had been acting when she was spending time with her father all these years, acting.
That very much hurt her father.
Okay. Now, Ms. Whiteford makes reference to Annie's subject minor's therapist. Who was the subject minor's therapist?
I believe it was a Miss Harper,
Okay,
but she only went twice.
correct. But what's important is that Annie is not reporting any type of abuse, neglect, or other issues with her father, correct?
That is correct.
And then this last paragraph, quote, "It appears that Mom's thoughts are that the problems lie solely with Dad. Therefore, if we get rid of Dad, the problem is solved." Is that what she,
Yeah, that's what she said.
just like this is a relatively long letter. At page 173, you've already testified to this. Mom's attitude is much more permissive. Dad's attitude is structured.
Their parenting styles are different.
Parenting styles.
Right.
That doesn't mean they're wrong in their parenting styles, it just means they have a different approach.
Again, a normal range parent, there's a wide variety of parenting styles. It's when you get outside of the normal range, which mother was,
What,
that you have issues.
what are you relying on in indicating that to the family?
That she was out of range,
Yes,
the enmeshment, the cross-generational coalition, it's us against him. He can just go back to Brazil, where he came from. We don't need him. The child not being able to articulate what her problems were. She was protecting her mom. The problems were the adult conflict, and a child turned into a psychological battleground. And I know you don't want me to use those terms, but that is my thought process.
did you determine that Mom and subject minor were talking about the reunification?
Absolutely.
Okay.
She
Upon
gave,
what-
she gave the child an email from the therapist that was directed to Mom.
In the middle of 173, she opines, "I believe that subject minor is a child of divorce that is in the middle of the conflicts with her parents. If subject minor is spending all of her days being schooled by Mom, going to the dance studio with Mom, and is really close to Mom, of course she is going to see Dad as the enemy." A fairly strong term.
It is a very strong term, but it's unfortunately a reality.
All right. Then, in that same paragraph, this stance is being supported and championed by her mother, correct?
I thought that was a strong word too, championed. That means wholeheartedly supported, contrary to everything that's in the child's best interest.
Yet, Ms. Whiteford is still recommending that the counseling continue because she indicates it makes sense to align with the parent that she's closest to and who she observes as being victimized.
Right.
Now Mom is the victim.
Yes.
Okay. However, continuing with the quote, "However, discarding her previous relationship with Dad is not the answer." In other words, she's still recommending steps be taken toward the reunification.
What is the alternative?
Well, the alternative is what?
Dad walks away and says goodbye,
Correct.
and they win? That he's out of her life, and he loves her very much, and he cares for her very much, and all he wants to do is have a normal relationship? So what's he supposed to do? It's not happening, Mom's not facilitating, the child is refusing, and therapy is the only answer. That's what has to happen. Or he walks away. What are the options?
At page 174, Ms. Whiteford indicates it seems that mom believes that she has subject minder's best interest by promoting her daughter, by protecting her daughter from her father. However, mom supporting that relationship with dad is the best thing she could do for her. In other words, encourage the relationship with dad.
Child needs to have two parents. And she had a parent that loves her. And that relationship wasn't being fostered. It's not in a child's best interest to cut a parent out that wants to show love, affection, and attention.
Now, you had set a status hearing for January 28, 2016, and you just made reference to Ms. Whiteford's letter of January 21, 2016. On the notation in reference to January 28, the first time you indicate that exchanges are to occur at Donna's house. What is Donna's house, so that the panel understands? What is Donna's house?
Donna's house is, as a point of history, Judge Steele created it when a court staff was murdered by her significant other, ex-husband, in a domestic violence situation over a child custody exchange. So she created this entity that's on the family court campus. It's not a house, it's an office, it's at the mediation center that protects people when they're in high conflict. And you go to Donna's house, it's monitored exchanges. They report to the court, but they have to go through an orientation process. They have to know the rules. They have to go through the security gate, like the airport where, there are metal detectors. That's what Donna's house is.
All right. Now, at page 176, you receive an additional report from Ms. Whiteford. Are you familiar with that?
I'm there.
Okay. Part of her recommendations, and she does articulate the fact that mom is not showing up for appointments with subject matter.
She scheduled various appointments and they weren't participating.
And you had ordered family reunification therapy, correct?
Many times.
Okay. I have not had a reunification appointment with dad and his daughter since September 24, 2015. My office on several occasions has tried to schedule appointments with mom and subject minor. The last scheduled appointment was December 10th. Mom was aware of the appointment. She made contact with us the day before the appointment. Mom made it clear that she would not be bringing any subject minor because she could not afford the sessions and because it stressed subject minor and gave her headaches, correct?
Yes.
So between the dates articulated in Ms. Whiteford's letter and this January 21 letter, there hadn't been any further visitations between dad and the subject minor, correct?
Correct. The only contact you had was in the 3 sessions with Bradford.
Yet her recommendations are dad should be able to start having access to his daughter weekly. There should be a 4-week plan in place. And she talks about what the weeks are.
She did.
And she makes several other recommendations.
Yes, she does.
Did you adopt those recommendations?
House.
The reason I ask is as all exchanges take place at Donna's house.
Right. Well, I'm just reading all of them. The dad participate monthly. Most of these I did. At some point, I ordered them to parenting classes, also through UNLV. But yes, the exchanges to be done at Donna's house.
Now, by February 16th, Donna's house advises you that they are closing their case because subject minor refuses to go with natural father.
Yes,
Correct?
yes.
Now, by way of summary, what efforts have been made to get the subject minor to Donna's house and then ultimately to meet with dad for the exchange that had been recommended by you?
What do you mean, what efforts have been made?
Well, did mom take her?
She took her.
Okay. Did subject minor get out of the car?
I don't recall.
Okay. Were there reunifications meetings with dad?
At Donna's house?
Yes.
No,
Okay. Do you recall why?
the child refused to go.
How many different times?
2 or 3.
So by this point in time, and actually continuing through this point in time, subject minor is making the decisions as to what she is and isn't going to do.
I think the coalition was making the decisions. Subject minor with the support of the mother wholeheartedly.
But dad is getting no visitations.
None.
Now, you set an evidentiary hearing for March 29th, and then it was reset to 5/12 to allow time for a custody evaluation.
Yes, a full custody evaluation by Claudia Schwartz, marriage and family therapist.
Now, who's Claudia Schwartz?
She's a marriage and family therapist in the community that performs these services. There are several that do, but I thought her fees would be more reasonable and affordable for the parties rather than a PhD. And the outsourced custody evaluation, as part of it, consists of a full psychological evaluation, which in this case I thought was needed due to what appeared to me to be parental alienation.
Right. And at 178 is Ms. Schwartz's letter to you indicating that natural mother is indicating she cannot afford it.
Go and explain yes, she said she was unable to afford.
Now, there's an additional letter at 179 from a Ms. Steinkamp. Are you familiar with her?
Yes,
Who is Ms. Steinkamp?
she's also a marriage and family therapist that I appointed to be a parenting coordinator. That's a liaison between two parents who are high conflict and they cannot communicate effectively or respectfully. So they communicate through the parenting coordinator, and that was going to be her role.
So this was the next move that you made in an effort to assure reunification.
Yes,
Okay. And pursuant to the letter of April 10th, it indicates, quote, Ms. Silva disagrees with everything. Close quote.
Are you at 179?
I am.
Okay, Ms. Silva, yeah, that's what it says. Ms. Silva disagrees with everything, and that she smelled like pot.
Correct. Now, did Ms. Steinkamp continue in her services?
Not really.
There is, however, another letter dated June 12, 2017, at 182 from Ms. Steinkamp.
Yes, there is.
Take a look at that.
Yes.
Okay. And can you summarize that letter?
Well, at first impression, she seems to be including reports from other therapists because she talks about history and the minor child's statements, and she, to my knowledge, did not interview the child. She had no authority to do that. She was simply the liaison between the parents. PC for short, parenting coordinator, is just to help them communicate.
She
So-
indicates at 182 that she interviewed subject minor, and she is adamant she does not want to see father at all.
I'm not sure she interviewed her or if she's taking, I don't know. I didn't provide her any reports, but I don't know if she's taking these comments from someone else. Because she also indicates the wrong age for the child, so I don't know what she's relying on there. I did not talk to her about it.
Who appointed her to have any involvement in this case?
I did,
Okay, for what purpose?
just to be the liaison, the communications person
Okay.
between mom and dad.
What does typically a liaison person do?
Because they can't communicate effectively with each other, they communicate with the parenting coordinator. And the parenting coordinator contacts the other parent. And the parenting coordinator may have communications with both of them, like have them on a conference call or circulate emails, but they filter out the vindictive, disparaging comments, the conflict. They reduced the conflict.
She, interestingly enough, at 183, either comes up with her own opinion or again is relying on somebody else, that it is apparent that subject minor and mother are enmeshed.
I saw that word many times.
So, you find that interesting? It's the same terminology that Ms. Whiteford is using?
Yes.
Okay. She also goes on to say, she, the subject minor, is almost 12, and she likely knows her way around the internet.
Yeah.
What did you construe that as, Steve?
Well, this was after I changed custody on a temporary basis.
Correct?
And I believe what she was referring to was the posting of this video of the child crying by mother on YouTube.
By that time, what had been posted on YouTube?
The video we saw today.
The video that we just saw.
I have to object. She's being charged with violating Nevada law and Nevada Judicial Code up to June 15th, 2016. And anything that happens after that is not really relevant to our proceedings here today. Ask that the references to whether or not this tape was played on the internet should be stricken.
And I'll leave that one with the chair. However, the comment about this case ended on the day of the video that we saw is incorrect. There was an order to show cause hearing that was set at a later point in time that we intend to have testimony in reference to this issue.
As to the testimony regarding the video on YouTube, I'm going to sustain that objection and allow you to, as other issues come up, to renew your objection. So that it's sustained.
Thank you, Mr. Chairman. May I have your indulgence for 1 second?
Of course.
I want you to turn to the Respondent's Exhibit book, page 125. And this is the same journal entry that my colleague made reference to of June 8, 2016. You have that in front of you?
Yes, I do.
Now, within this journal entry, which is 5 pages long, you recount certain facts, correct?
Yes.
My colleague didn't necessarily go into those, but for example, this case has a lengthy troubled history since the parties' divorce of April 26, 2013. They've been before the court no less than 9 times, primarily on father's motions to enforce his custody rights, etc.
Right,
Correct?
right.
Okay. When you go on to articulate the facts that have been ascertained on this case since you have been the judge on this case, correct?
I do.
You make reference to the wealthy reports, you make reference to Donna's house, etc., and the failures to effectuate reunification.
Yes.
By this point in time, had you determined that the parental alienation was obviously present?
Absolutely.
Did you determine that mother was interfering with the reunification process?
Yes.
Okay. Is it for that reason that you directed that the subject minor be brought to court?
Yes.
By the date of this order, had you already, journal entry, I beg your pardon, had you already determined that a temporary change of custody was appropriate?
Yes.
And was it based upon that which is set forth within this journal?
These are the highlights,
Correct.
obviously. I couldn't draft a 10-page journal entry, but I felt it important to describe the efforts that I had made to try to reunify the child and the father. And those were part of my findings to temporarily transfer custody.
Now, prior to this journal entry, Dad had filed requests for order to show cause why Mom should not be held in contempt, correct?
Correct, and I hadn't ruled on those. He had 2 motions to have her held in contempt, and he had 2 motions to change custody.
And
And
those
rather,
hadn't been ruled on.
rather than granting or denying, I chose to deal with it therapeutically, but they were still pending.
Now, at page 128, you indicate, this court finds that plaintiff, natural mother, is in contempt of the court's order to facilitate visitation on weekends with the father. An order to show cause shall issue.
Yes,
Once again, the change of custody wasn't as a result of your, quote, finding, close quote, of contempt. Is that correct?
not at all.
What was the change of custody based upon?
What we had been enduring for the last year was mother withholding the child, mother committing parental alienation, the child not going, and therapy failing because mom wouldn't encourage and facilitate. She wouldn't participate in therapy.
Did you feel it was in the best interest of the minor child to have a relationship with her father?
Of course.
Had Miss Silva ever filed anything that said, I don't want my daughter to have any relationship with her father?
She filed anything? I don't recall.
It would be basically a motion to terminate parental
Oh,
rights.
no.
Okay, that type of document had never been filed.
No.
Filed, I beg your pardon. And then you continue, an order to show cause is also issued against plaintiff for not complying with the court's orders to refinance the house or have it sold, correct?
Home equity line of credit, correct.
Okay. And a further order to show cause is further issued against plaintiff for not having the subject minor tested for math proficiency. Now, this is from the order that you entered in February of 2015, correct?
I believe it was over a year
Okay.
prior.
Well, as of June 8th, it would have been over a year.
Yeah. It was in 2015. There were a couple of orders.
Then you indicate at 129, the order to show cause hearing shall be scheduled for July 28th, status check set for July 28th. At 10 is hereby vacated, correct, at page 129?
Right, there wasn't a need for a status check because the order to show cause hearing had been set.
Right, and on June 15th is the date that the panel has seen the hearing. Did
It's
you
not a
feel-
hearing.
Well,
It was a
the
child custody
change of
exchange.
custody. Did you feel you had any other choice at that point in time other than a change of custody?
No.
And why is that?
I had tried everything. I used every resource that was available to me. There was nothing else I could do.
And this was based upon your training and experience.
The experts that I had, the reunification therapist, the parenting coordinator, Donna's house, I didn't have anything else I could do. I didn't have another way to address this.
Well, you could have continued it. Could have gone on and on and on and on and on for another 2-3 years, Judge. Why didn't you do that?
That's not appropriate, because all this while, the child is not having a relationship with her father, and there's nothing wrong with her father.
And the longer she's away from her father, the harder reunification is
It's,
going to be.
there's no other way to do it, and my job is very tough, and I took no pleasure in doing that.
Now, what isn't shown here is that there's a point in time, when I say here, the video that we saw, there's a point in time when you addressed the subject minor, just you and she.
Yes,
Is this permissible?
yes.
Under what authority?
Under the best interest of the child, the court has great latitude. There's case law on that I can make any order as I deem best interest of the child.
During that 9 minutes, what, if anything, was your exchange with the subject minor? Was it an interrogation?
It was not, I did not
How would
ask
you
her questions.
characterize it?
It was an opportunity for me to explain to her what was happening and why.
And did you do that?
I did that, yes.
Okay. Was she upset?
No.
Now, you see her crying on this video, and you ultimately go back on and order that she go with Dad.
Right.
Okay. Is your testimony she wasn't crying when you and she were together?
Absolutely not.
Okay. Your court clerk was likewise present, correct?
And my marshal.
And your marshal. Why did you do that out of the presence of all other parties and just you and the subject matter and not on video?
Okay, that's a lot. So why did I not do it on video? Am I allowed to answer that? We don't videotape children because the parents can misuse those videos and put them on YouTube. And I know you made an objection to that.
Okay,
But I'm
that's
trying to
probably good
protect the
enough.
child. It's not in the best interest of the child to videotape her because it can be misused. Second of all, as in a child interview, which this was not an interview, it wasn't under Chapter 50, we seal those so they can't be misused. So that's why it wasn't videotaped. The reason that the parents were asked to leave was that they could not influence the message that I was trying to deliver to this child. They couldn't construe it for the child, they couldn't comment, and I wanted the child to understand that this is my decision. I have made this decision for your best interest. And I didn't want her to blame her father, because I'm now temporarily placing her with her father to stop the coalition that happened, and this is a recommended treatment method of parental alienation, where you temporarily issue an order of no contact by the allied parent. You put the child with the targeted parent and allow them to form a relationship without any interference. They once had a great relationship, they were on their way to getting a good relationship, and they needed time to be together without her interference. And so I explained to her, I'm doing this for your best interest. I said, your father loves you very much, and he just wants to spend time with you. Please give him a chance. Please decide that you will open your heart to him and you will go with him. He misses you and he cares for you.
Did it appear to you that she was willing to do that?
She said, I will not. 3 times.
With
Crossed
her arms folded?
Yes. And I said, child's name, this is very important. You need a father in your life. And she started asking me questions and posing scenarios to me. A what if scenario, what if this, and what if this? And I answered her questions. And that was it.
Now, ultimately, she went with her father that day,
She did.
correct?
She did.
She never went to Child Haven?
No.
Okay. And pursuant to your temporary order, she was ordered to spend the summer with her father?
Yes.
Okay. And ultimately, on 7/28, according to the chronology, that's when Mrs. Silva files the objections to the further hearing that was going to occur. And you granted the objections, correct?
Well, as to the May 12th order, because the council, unbeknownst to me, did not have that finalized. The May
You
12th
never
order
made up
was the
the
Donna's
order.
House exchange.
So there was no order to show cause to proceed upon, correct?
I issued the order to show cause because I didn't know that the May 12th, there was a handwritten order for Donna's House. That was an order. But I didn't know council was not successful in getting her order turned in because I had a temporary clerk and she rejected the order, but the temporary clerk didn't advise me of that. My clerk would have told me.
Okay, if you look at 133, the exhibits in front of you. This is dated July 28th of 2016.
Yes.
It makes reference to that.
Oh, okay.
Look at that, see if it refreshes your memory.
Right, the order had not been signed or filed regarding Donna's house. The handwritten order had been done, but council had not submitted the order with the findings.
Now, the natural mother also filed a motion for reconsideration. Is that correct? 10/4/16.
After I made my decision on the math testing.
Correct. And just so we're clear, after a hearing, did you hold her in contempt on any items?
At the order to show cause hearing, I believe the only thing we proceeded on was the HELOC, maybe, no, not the HELOC. The math testing that was
Correct.
ordered over a year ago.
The one from February
Yes,
of 15.
that was the only thing she was held in contempt on and sanctioned,
And what was the sanction?
$500.
Now, by October 14th, she files a motion for reconsideration. The motion is denied. Dad's counter motion for fees is granted, and the court reiterates that mom was not held in contempt for violating any visitation orders.
That's correct.
Is that correct?
That is correct.
Now, up to this point in time, you hadn't been recused from the case, correct?
I was never recused.
On 10/11/16 is the evidentiary hearing on the modification of custody.
That was when it was scheduled, it didn't take place.
Correct. Okay. And once again, why didn't it take place?
Parties stipulated that father would continue to have temporary sole legal custody, primary physical custody, and mom would have visitation 1 week on a Saturday and the next week on a Sunday, alternating.
And that was pursuant to stipulation.
Stipulation through council,
Okay.
but the parties were present.
And both were represented by counsel.
Yes. And I ordered them to parenting classes. I continued the evidentiary hearing at their request.
Mr. Chairman, recognizing that you've given us a period of time to present Judge Hughes' case too, I believe that would be the end of my cross-examination. And I will turn over to Mr. Reno.
No questions? Sure. Why don't we take let's take a 10-minute break.
Thank you.
Thank you.